topic, other remedies when contract theory fails.
Mom,
Before we identify those remedies, let's start by remembering why contract law is so powerful and why a contract remedy is nearly always better than the alternatives we're about to discuss.
Okay, 1 second.
Here are the advantages of basic contract law. Number one, contract law awards the injured party the expectation interest, including any lost benefit of the bargain. That's the great deal the injured party had in the contract. The difference between the value of what the breaching party promised to pay or deliver and the value of what the injured party promised to pay or deliver in return.
Baba, you're 20. You're 20.
Number two,
20, Baba.
contract law doesn't require an injured party to prove reliance. The injured party needs only to prove a bargain for exchange.
Baba,
In case you've forgotten just how important these virtues are, consider a couple of examples.
Okay.
Buyer and seller make a contract at 11 a.m. for a sale of oil at that moment's market price. At 11:05 a.m., war breaks out in the Middle East. The market price of oil suddenly doubles. This is great news for buyer. Not that there's a war, that's bad. But suddenly, buyer has a clear benefit of the bargain. She'll get the oil seller promised at the 11 a.m. price, and she can resell the oil at the 11:05 a.m. price. She'll make a very fast 100% profit. It's bad news for the seller. Seller cancels the contract. When buyer protests, seller says, "Hey, you haven't spent a dime in this transaction. How could you have relied on my promise? We just made this transaction 5 minutes ago." Do you feel sorry for seller? Don't. Seller probably wins at bargaining at least half the time. He'll be fine, especially because he still has plenty of other oil he can now sell at an extravagantly new high price. And buyer's right to enforce the contract without proving reliance is important. If contracts like this aren't enforceable, the stock market, commodities market, and perhaps the real estate market will collapse on the spot. What's the point of doing deals if a deal can be broken that easily? We're back to primitive barter. Here's one more example to remind you of the advantages of contract law based on bargain for exchange theory. Many of you have day jobs if you're taking this course online. Your job might come with benefits. You probably considered some of those benefits when you accepted the job. Everybody wants paid vacation time, but what about disability insurance? It's not something you might think about until you become disabled. Suppose worker becomes disabled. He tells boss, "I might have to resign. I can't work anymore." Boss says, "Be sure to file for your company disability insurance." Worker says, "What? We have disability insurance?" "Yes," boss says. "It's right there in the handbook you signed when you accepted the job. But now I have to report to Human Resources that you didn't know about it. If you didn't know, you couldn't have relied on it. And that means we don't have to keep this promise for you." Fortunately, boss is dead wrong. It isn't necessary for worker to prove reliance. Worker only needs to prove bargain for exchange. Did he assent to the handbook? Yes. He signed the handbook even though he didn't read all of it. Did he give consideration? Yes, he worked in return for his current rate of pay and the benefits described in the handbook, even the benefits he never read about. Worker wins. But now I have a confession to make. Contract theory isn't always that great. There are times when you need an alternative to contract theory. The main reason you need an alternative is that a broken promise can still hurt even when there's no contract. This brings us to Ricketts versus Scotthorn, where Grandpa made a gift promise to his unfortunate granddaughter, Katie. I need to give a trigger warning here. There's a sexist side to this case. Unfortunately, the sexist side is important to understand why Grandpa believed he needed to make this gift and why a panel of middle-aged male judges were determined to enforce Grandpa's promise. Recognizing the sexist side is also important for seeing how values affect our perspective of justice. The outcome might be the same today, but Katie's case might be less compelling. Grandpa thought Katie was in need. She was getting on in years, maybe in her late 20s and early 30s, and she hadn't married. At the time of this case, at the end of the 19th century, Katie's failure to marry would have made her the object of pity. And in fact, not marrying probably did diminish her economically and socially. Unmarried women were tragic, even among other women at that time. The unmarried woman was caricatured as an old maid. There was even a card game named Old Maid. The one card you didn't want was the Old Maid card. Because Katie wasn't married, she had to work to support herself.
Put it in the trash.
She was a bookkeeper for a local store. It was a low-paying job. It wasn't necessarily a reflection of her lack of skill or intelligence. Job discrimination against women was severe.
You guys
There
have to go
weren't
get baths.
many job
Go.
openings available for women back then. They couldn't be doctors, lawyers, or business executives. Katie probably lived at home on the farm with her parents, which would have been the norm for an unmarried woman.
No.
Her low pay as a bookkeeper probably wasn't enough to pay rent for a separate dwelling. Her parents probably supported her, but eventually they died.
Sometimes you have to
and
ask.
she would have needed to earn money for her own retirement. This was long before Social Security.
I cannot because I'm
So
watching
Grandpa
this. Come on,
felt
you
a
have to.
need to do
Come on, you have to
something
go
for
back.
Katie.
Come.
He was proud of the fact that his other
with me, man.
grandchildren didn't
Put it in the
have
trash.
to work in such jobs, either because they were married, or in the case of the men, they had their own farms. One day,
Come on,
Grandpa
Mama.
went to the store where
Come on, this
Katie
way.
worked. He gave her
Okay,
a
everybody's
note
going.
promising
Bye.
to pay $2,000 with interest.
Bye.
The purpose, Grandpa said, was to make sure she wouldn't have to work.
Okay, bye.
Not a lot of money, even when adjusted for inflation. In today's dollars, it was about $18,000, the equivalent of a year's rent. But it made Katie so happy she cried. Even if it wasn't really enough to support her for life, it was a touching act of generosity from an old man who didn't have a great fortune. The note Grandpa wrote for Katie was what's called a promissory note and a demand note, meaning it gave Katie the right to demand payment immediately, assuming no defense against the promise. But they both seemed to have understood that the note was to be folded up and put away for the future. Why not just give Katie $2,000 cash? And why didn't Katie ask for immediate
Mama gonna
payment?
make chocolate milk.
Grandpa's
Mama gonna make
wealth was
chocolate
in
milk.
his farm, his home, and
Yeah,
his
go
source of
get some.
income. If he sold the farm to pay Katie,
Mama has it. Go
he'd
get
be
some.
homeless and without income for himself. Katie must have understood this. Even though the note gave her the right to demand payment, she chose to wait. She understood Grandpa's position. If Grandpa didn't have the money when he made the promise, why not just leave the money to Katie in his will? That way he could have lived on his farm until he passed away, and that might be about the time Katie would need to retire. Grandpa didn't do it that way because he wanted to see the joy in Katie's face. A gift just isn't the same if you're not alive to present it yourself. Unfortunately,
Yeah.
Grandpa was a farmer, not a lawyer. He didn't understand how to make this work. He died perhaps sooner than he expected without having paid the promised $2,000 and without making the same provision in a will. When Grandpa was dead, he didn't need the farm anymore. Katie presented the note to the administrator of Grandpa's estate and demanded
Mama has
payment.
chocolate milk.
The administrator said no. That's
No, my
what
teacher.
led to Katie's lawsuit. Could Katie win under bargain for exchange theory? Did Grandpa receive consideration for his promise to pay $2,000?
Why?
No. Grandpa required nothing in return and received nothing in return. His purpose was to enable Katie to quit her job, but her quitting was not consideration. Gifts are often for the purpose of enabling someone to live better, and a gift is very plausible. The fact that Katie and Grandpa were family, together with other circumstances, made a gift very likely. Katie gets nothing under bargain for exchange theory. But Katie had another theory for recovery: equitable estoppel. Equitable estoppel is an idea that eventually merged with a branch of ancient assumption to form what is now widely called promissory estoppel. The court's description of the doctrine as equitable is important because equity is a branch of law theoretically separate from the common law. Equity empowers a court to think outside the box, to be inventive, and to seek justice based on the unique facts of every case.
Yes.
Here's some historical context to make the court's reference to equity important. Centuries ago, the king or queen of England had absolute power. Every now and then, the monarch would invite subjects to come before the throne to ask for help with an individual problem. The monarch's devoted subjects would say, "Your Highness, the courts have failed me. It's 1500 and the common law is so primitive. These judges still don't know what a contract is. But Your Highness is almighty. Can you decide this case for me?" I'll bet the kings and queens of England really enjoyed this part of their job. Word got around fast that if the usual judges wouldn't help you, the king or queen might help. The next thing you know, huge lines were forming outside the Tower of London, and these weren't just tourists. The monarchy needed help. Over time, the kings and queens of England delegated power to chancellors. The chancellors built up their own separate court system existing parallel to the regular common law system. The chancellor's power to decide cases came straight from the monarchy, and they were famous for deciding cases based on equity. They were allowed and expected to bend the rules in the interest of fairness. That's just the beginning of a much more complicated story. The important thing for today's purpose is that the court in Ricketts versus Scotthorne was signaling that it was acting like a chancellor doling out justice based on this idea of equity. Fairness trumps the usual rules of law. To explain the injustice of the estate's defense against Katie's claim, the court referred to cases in which a promisor led a promisee down a path by a certain promise, only for the promisor to change its mind and deny the promise. The promisee's going down that path is often described as a detrimental change in position, going down one path rather than another. The modern term is reliance. Grandpa's promise had led Katie down a certain path, and now equity has stopped Grandpa's administrator from denying the enforceability of the promise. It's as if the judge had placed its hand over the mouth of the administrator to stop the administrator from denying its duty to pay the $2,000 note. Let's fast forward to the next century, to the modern restatement of contracts. By then, the concept of equitable estoppel had merged with some old ideas of a subset to form what we now call promissory estoppel. Restatement Section 90 suggests 4 elements of promissory estoppel. The courts have described this theory in many different ways, and not always the way the restatement describes the theory. I've simplified and reordered the 4 elements to better explain how modern courts usually apply the theory. Number 1, the promisor made a promise, even if the promise was too indefinite to be part of a contract. Number 2, the promisee reasonably relied on the promise to its detriment. Number 3, the promisor should have expected its promise to cause such reliance. Number 4, justice requires enforcement of the promise. Let's evaluate Ricketts versus Scotthorn under modern promissory estoppel theory with our modern sensibilities. First, did Grandpa make a promise? Check. Grandpa did make a promise. And let's add, we're certain Grandpa made the promise. It's in writing. Grandpa presented the writing in front of several witnesses, and then Grandpa's subsequent conduct corroborated the promise. He acted in accordance with the promise up to his death by paying interest. Second, did Katie reasonably and materially rely on this promise to her detriment? I'm neutral on this. The restatement doesn't list reasonable and material reliance as a separate element, but seems to treat reasonable and material reliance as subsumed under parts 2 and 4. Most modern courts state reasonable and material reliance as a separate element, and that's the way I presented it here. And this is where Katie might face trouble in the modern world. What was her reliance on the promise? What was the path she traveled only because of the promise? Don't confuse reliance with hope or disappointment. Disappointment isn't a cause of action for a lawsuit. Reliance is a loss or an injury. Katie might have relied on the promise by resigning from her job. She lost income she otherwise would have earned. Was it reasonable for Katie to rely that way? It must have been clear to her that Grandpa didn't have the money yet. He had to die first. Grandpa lived longer than expected, so Katie went back to work. It looks to me like Katie didn't quit her job because of the promise. She quit her job because Grandpa was embarrassed by her working. Maybe she worried that if she didn't quit, she'd seem ungrateful to Grandpa. But let's assume Katie quit just because of the promise. A modern court might still disagree that her reliance was reasonable. Don't get too overeager for your older relatives to die. Third, should Grandpa have expected Katie to rely in this way? Yes, Grandpa definitely should have expected Katie to quit her job. What was his purpose in making the promise? To enable Katie to quit. Fourth, does justice require enforcement of the promise? This is the wild card if promissory estoppel is a matter of equity, as the court suggested in Ricketts. Equity invites a court to consider its own sense of fairness based on any facts relevant to fairness. Equity tends to treat each case as the first of its kind, an opportunity for a court to reconsider its sense of what justice means. If we approach this case as a matter of equity, what's so unfair about rejecting Katie's claim? A couple of things come to mind. First, we're certain Grandpa wanted to keep his promise. To his dying day, he expressed his desire to keep his promise. Now he's dead, And it seems a shame that the administrator should deny what Grandpa intended. Second, Katie was the object of pity. It wasn't just Grandpa who felt sorry for her. The judges felt sorry for her. Society and the labor market punished Katie every day for not getting married. Slight changes in the facts might tip the scales of equity against Katie. Suppose Katie had been impatient. She didn't wait until Grandpa died. She wanted the money now, and she was willing to put poor Grandpa out of his home so she could have the money now. Which way does equity point? Suppose that not long after Grandpa's promise, the richest man in Nebraska fell in love with Katie. They married, and Katie became the richest woman in Nebraska. In the meantime, the husband of Grandpa's other granddaughter, Hilda, was killed in a farming accident, leaving Hilda with 6 children and thousands of dollars in debt. If the administrator pays $2,000 to Katie, the estate will be reduced to 0, and there will be no money left for Hilda. Which way does equity point? Finally, suppose Katie is an unmarried man, Ken. Ken lives in his mother's basement and works part-time when he's not smoking that strange weed from Mexico. Grandpa hoped that Ken would use the money to go to law school, but everybody knows Ken will just use the money for drugs and gambling. Which way does equity point? Now let's see if some of the losing cases you read before might come out differently under promissory estoppel. Remember Kirksey versus Kirksey? Isaac promised his sister-in-law Antilico that he'd give her a place to stay with her children because Antilico's husband had died. Number 1, do we have a promise? Check. Number 2, did Antilico rely in a reasonable and material way? I'm neutral on this point. She relied by abandoning her home and moving with her children to Isaac's property. Was that a reasonable thing to do? Yes, it was reasonable to move her family to a better part of the state. What was not reasonable was giving up her stake in her original family property in the South. All she had to do was to register that property. Failing to register her homestead was her own fault. Maybe that property was so bad it wasn't worth the effort to go to the courthouse to register her claim. I'd be more impressed with her reliance if she'd invested heavily by her own labor or money to develop the land Isaac gave to her. Number 3, should Isaac have expected this reliance? Check. He certainly should have expected Antilico to move to his property. That was the whole reason for his promise, to persuade her to move. Number 4, does justice require enforcement of this promise? I'm unsure. There seems to have been a complete failure by Antilico's lawyer to present facts that would have persuaded the court that justice leaned in her favor. Of course, it's also possible that the unknown facts just weren't in Antilico's favor. Here are some facts I'd like to know. Did Isaac promise a place to stay for life, or just until she had a chance to get her life together? Why did Isaac expel her? Was he being mean, or was she a bad household guest? Finally, did she really lose anything? Was her old home worthless? Did she need to leave that part of Alabama anyway? We'll never know. As sympathetic as I am for a frontier woman who's a single mom struggling to survive with her young children, I can't say for sure promissory estoppel theory would have helped. Maybe the strongest part of her case is that she's at least as sympathetic as Katie. What about another one of our old cases, Feinberg versus Pfeiffer? Surprise! Mrs. Feinberg won after all on the theory of promissory estoppel. Number one, did the company make a promise? Check. Number two, did Feinberg rely? Check. Her alliance was in resigning earlier than she might have, foregoing the preservation of her career because she didn't believe she needed current income anymore. Had she continued to work, she probably would have earned more savings for her retirement. Number three, should the company have expected this reliance? Check. The purpose of the promise of a pension was to enable Feinberg to retire. Number four, does justice require enforcement of this promise? Check. There's a scandal during this era of big businesses breaking their promises of pensions because their promises were stated in illusory form, discretionary, gratuitous, and without consideration. This case is one court's shot across the bow to employers. Keep your promises when it comes to pensions. Now let's move on to the next subsection of this chapter on other remedies, reliance on an offer. The remedy described here is a variation of promissory estoppel, but it's based on an offer, not a promise. First, a little background. Negotiations often fail. Neither party made an offer that could be accepted, or one party made an offer and the other party chose not to accept it. This can be disappointing for one or both parties. It's not just that the hope of a contract has been dashed.
Good.
Sometimes one of the parties spent a lot of money and effort seeking
Clean
a
is
contract.
good. We like clean.
First, there's the time, effort, and expense of negotiating. There might be entertainment and other relationship-building expenses like taking a potential client to an NFL football game. Then there might be research and inspection fees or loan application fees. And finally, there are the missed opportunities to negotiate with other parties who've now wandered away. In general, there's no remedy for the costs and losses of failed negotiations. You can't sue someone for failing to agree to terms with you. The next case, Drennan versus Star Paving, established an exception to the general rule. The plaintiff was a general contractor who bid on a construction job with the local school district. As a general contractor, Drennan managed and supervised construction work by independent subcontractors he selected to help him with the project. Drennan's first step was to estimate the costs of the work plus a respectable profit for himself. To calculate the costs, he had to ask for bids from subcontractors who might do various parts of the project for him. In this case, one of the subcontractors was Star Paving. Star Paving gave Drennan a bid, and Drennan added that bid to the amount of his own bid for the general contract. Good news! Drennan won the general contract. His bid was the lowest of all bids submitted by general contractors. For a general contractor, this moment is a mixture of joy and anxiety. I won! My bid was the lowest. And then there's the anxiety. Why was my bid so much lower than everyone else's bid? Is it possible I made a mistake? Did I leave something out? Drennan should have been anxious because one of his subcontractors, Star Paving, had made a mistake. Star Paving miscalculated its own costs in making an offer to perform paving work for Drennan. There was no contract between Star Paving and Drennan. Star Paving made an offer to Drennan, but Drennan waited to accept because he didn't want to be bound to Star Paving until he knew he'd won the general contract. Once Drennan had won the general contract, he drove to Star Paving's office to deliver the good news and to accept Star Paving's offer. As quickly as Drennan could introduce himself and before he could accept, Star Paving revoked. Ordinarily, this would be the end of it. There was no contract. But Drennan sued because he had relied on Star Paving's offer. Now he was bound in his contract with the school district to finish the project for a price likely to be less than his actual cost to perform the work. Judge Traynor, who's famous for pushing the boundaries of tort and contract law, applied an analysis that resembles promissory estoppel, but it's not promissory estoppel. If we apply promissory estoppel, we stop at number one. Did Star Paving make a promise? No. Star Paving made no promise. Star Paving made an offer, which is not a promise. An offer might become a promise if it's accepted before revocation, but Star Paving revoked before acceptance. Still, Justice Traynor applied a variation of estoppel, offer estoppel. Restatement section 87 subpart 2 describes offer estoppel as follows.
Trees are gonna shake.
Number one, an offeror made an offer. Number two, the offeree reasonably and materially relied on the offer. Number three, the offeror should have expected its offer to cause such reliance. Number four, justice requires a court to treat the offer as irrevocable so that the offeree has a reasonable chance to accept it. Let's apply this test to the facts in Drennan versus Star Paving. Number one, did Star Paving make an offer? Yes, clearly. Check. Number two, did Drennan reasonably and materially rely on the offer? I'm neutral. His reliance was certainly material. Drennan bound himself to the school district to perform a project at a price based on Star Paving's offer for a subcontract. Drennan might now have to work at a loss or for a greatly reduced profit. But was this reliance reasonable? The problem is that Drennan could have protected himself by requiring an irrevocable offer from Star Paving or by making a contract conditional on Drennan winning the general contract. A lawyer would know that the solution to the party's problem was to make Star Paving's offer irrevocable or to make a contract conditional. Was it reasonable for Drennan to fail to do either of these two things and to rely on a revocable offer instead? Drennan seems to have gotten a pass on this issue because he didn't go to law school. You, on the other hand, might not get that free pass. You'd be expected to deal with this problem appropriately. Number three, should Star Paving have expected Drennan's reliance? Check. The purpose of the estimate or offer was that Drennan should use the offer, win the general contract, and hire Star Paving to do the job. Number four, does justice require treating the offer as irrevocable? Check. Considering how we've answered the other questions, the answer seems to be yes. That's all for now, until next time, when we'll explore the use of estoppel theory to remedy a hopelessly illusory or indefinite promise.